Greetings, this is Pastor Mike of the Remnant Church in Southern Oregon. We're here for another Investment in Truth review. The subject tonight is going to be Part 3, the biblical and legal status of the Church of God. The code number is still the same code number in this series and block of instruction, which is code 2019 V for video 0010. The date today is March 24th, 2019. The instruction that we'll be covering, it relates to the 8-part treatise that I wrote. I published it on Facebook back on the 23rd and 24th of November 2018. It's entitled A Remnant Epistle, a treatise, analysis, and study on the doctrine of the biblical and legal basis for the Church of God. That was under code number 2018A0207. It can be found at my Pastor Mike's Advanced Studies in Truth group. You just have to scroll down to it. It's down there a ways. I haven't...
On Facebook.
On Facebook, yes. On Facebook. I haven't reposted it since the first time I posted it, but I'll probably do that in the future. All right, we're going to jump right into the disclaimers. The information provided herein is for educational, truth, and knowledge purposes only. No specific course of action is directed, meaning we're not telling you to do any particular thing, except the advancement of knowledge and truth. I now state and clearly declare that I am addressing the subject matter set forth herein as a pastor of God in my religious and ecclesiastical capacity and office, and that I am exercising my official function to keep religious believers informed of their various rights, freedoms, and liberty under God and relative to their awareness and understanding of the various laws of man. Therefore, I hereby declare, claim, and assert any and all religious protections of whatsoever nature and kind, including protection from discrimination on the basis of religion, available under the inherent, inalienable, primary, and subordinate rights and laws. The Remnant Church in Southern Oregon, Mike Benjamins Jr., that's me, pastor, in both his personal and ecclesiastical capacities, including his subordinates and personnel, individually and jointly disclaim any and all liability and or responsibility for any damages sustained or suffered by the readers, viewers, or other entities in the implementation of the teaching set forth in this video or treatise. Okay, because I use the same disclaimer for my treatise. The material is provided as a research study project for learning purposes only, and any implementations and or applications contrary to my various cautionary statements, one of which will be mentioned in this block of instruction, are undertaken at the sole risk and peril of the readers, viewers, or entities. No statement is made or implied as to the ultimate outcome resulting from such implementations or applications. All right, we got a lot of ground to cover again. Bear with me, we're going to get through it. I'll be covering, it'll mostly be law and sovereignty and jurisdictional issues relating to the balance between church and state, and of course relating also to the status of the church. There will be some purely legal instruction, which may seem unrelated, but is related to the overall subject matter we will address in this study. So if we cover some area and you might think to yourself, well, this doesn't seem related to what we're talking about, believe me, I wouldn't take the time to go through it unless it was related. Although you're going to have to wait until you see all the videos when it's all done to be able to see the whole picture, especially for those who haven't read my treatise. The lawful status of God's sovereignty in the United States is the general heading here. The study, instruction, analysis, and narrative continues. I'm going to quote now from Sir Isaac Newton, who was alive from 1642 to 1727, And he had to say this: "A few scattered persons, which God hath chosen, can set themselves sincerely and honestly to the search after truth." All right, I want to make a little statement here before I really jump into it, and that is the Remnant Church, of which I'm a pastor, was founded by my father, Pastor Mike Benjamin Sr., and he passed away in 2009. He was born in 1920. The Remnant Church is not an incorporated church. I am not licensed to perform civil state marriages. We do not have tax exempt status from the system. We're operating outside of that. I'm working to, of course, I'm laying the foundation for the inherent rights and establishment of a true church under God, and that's why we do that. But if you're wondering whether or not we were like other churches in our legal status, we're not. All right, let's jump right in then. At this point in our expedition through the Valley of Truth, we have come a long way already, and we're going to go even farther. The truths that have been brought to light have given us keen and unique insight and understanding. I acknowledge that it has been difficult and disturbing for some, an epiphany for others, and refreshing for the knowledgeable and discerning. Needless to say, the truth is usually an abrupt awakening. And for many of you, I realize, some of you have never heard this before and probably never considered it. You just went ahead about your work, trying to get closer to God, and I understand that, and there's nothing wrong with that. Many people don't have the study background to understand these issues in detail. And that's what I'm trying to do here. I'm trying to bring you to the knowledge. I'm trying to give you back the key of knowledge so that you can see what things really are. The next subject that I must reveal to you is one that is especially revealing and yet is also particularly upsetting. As most of my readers know, I have spent many years studying and researching both biblical doctrine and the law. In some instances, these two areas of research merge together and overlap to reveal a significant yet overlooked truth. That is especially true in this case. Let us take a look at some very significant maxims of law. Now, here's where we're going to get into some legal stuff that you might think, again, I want to just say again, you might think, well, what does that have to do with what we're studying? Well, it does, believe me. Just bear with me and we'll go through these points, and I think you're going to probably have some epiphanies, and probably it's going to be, oh, that's how that works. That's really what I'm trying to do, is to get you to say, oh, that's how that works. I'll start off with 4 basic rules and definitions that I often refer back to. As one enters a serious study of sovereignty, jurisdiction, and the operation of laws, there are 4 points which are absolutely critical for the discernment of truth. An understanding and a knowledge of how to apply these points must be learned. They are, number 1, all the jurisdiction that is exercised over you comes from you. That means in some way you agreed to it or you consented to it. A failure to object in a timely manner is deadly. This refers to the idea that once you discover that something is wrong, that needs to be corrected, if you keep silent about it, they're fully capable of, not only capable, they're fully justified in saying nothing's wrong. And he's not objecting, and therefore his or her silence denotes agreement. So failure to object in a timely manner is deadly. There's one little wrinkle to that is, it depends on when you discovered that something was wrong. You may have for decades not known that something was wrong, so you didn't say anything. It's from the time that you discover the problem and the truth, that if you continue to remain silent, then the clock starts running on you. This word timely. You have to object in a timely manner. It doesn't do any good to find out in 1900 that you that there was a problem and you didn't say anything until 1980. That's a little bit too long. You didn't object, you see. Not timely, anyway. Number 3, all the evidence that will ever be used against you will be provided by you. This means that the evidence that the system would use against you somehow can be traced back to you. So that's something to really think about. I really don't think that really needs too much further explanation. Number 4, a license is permission to do that which would otherwise be deemed without the license illegal. That's an important one. I'm going to read it again. A license is permission to do that which would otherwise be deemed without the license illegal. Now, for those, I just add a little bit to it. A permit is just another way of saying license. Just remember that. Okay. Numbers 1, 2, and 3 are rules, maxims of law. Number 4 is a definition. For now it is sufficient that you learn these points and set them to memory. Later, as you grow in the knowledge of truth, you will realize their role and application. I like to call these the big 4. There are various other points, rules and definitions, which, especially when addressing issues of law and sovereignty, become most useful. Okay, I've numbered, that was the first 4. I'm numbering them right in order. So this is rule number 5. The law means what it states exactly, precisely, completely, and it doesn't mean what it doesn't state. A lot of people try to read things into the law that are not there. You want to avoid doing that. The law means what, let me read it again, give it extra emphasis. The law means what it states exactly, precisely, and completely, and it doesn't mean what it doesn't state. Number 6, this is a definition of sovereignty. We often talk about sovereignty, jurisdiction, kingship. Let's have a little bit of an understanding of what sovereignty means. Sovereignty means supreme in power, possessing supreme dominion. Dominion is another way of saying jurisdiction or sphere of control. It is supreme jurisdiction, authority, and ownership in the highest degree, without control, superior to all others. Within that particular rule, I want to add a little bit of something that I want you to, again, remember. I've said it in other videos. I'll go ahead and repeat it. Remember this phrase: only sovereignty trumps sovereignty. Important to remember. Number 7, the secular sovereignty of the people in a democratic republic is held collectively, as a collective sovereign body politic. In some sense, it is not held individually, with each member of the people holding the status of individual sovereign in every respect. For instance, the ownership of the public lands and resources is held in a collective sovereignty. Each individual in the sovereignty does not own all the lands and trees by themselves and cannot exercise individual sovereign ownership over all the public lands, trees, and other resources. So we own them together. Okay, important to remember. However, and there's somehow you'll probably say, "Oh, Pastor Mike, there's always a however." Okay, well, that's because you don't know the law on any particular subject until you know the exceptions to the law. So here it is. However, individual sovereign status does exist, as in various inherent and inalienable rights, freedoms, and liberty. That particular study, which I've talked about in other videos, is not going to be the main focus of this particular block of instruction. I do recommend that you read what I write and that you look at my other videos, by the way. 8. Individual judges are not bound by the judicial decisions of other judges in every instance. In the case of an appeal from a trial court, the trial judge is bound by the judicial decisions of the appellate court. In that instance, it is. A lower court judge is bound by the judicial decisions of a higher court judge who has specially reviewed the acts and or omissions of the lower court. That applies to appeals and special writs like a petition for writ of mandamus. On matters of prior case decisions, called precedents, and their applicability to active court matters, a judge is not absolutely bound to apply the judicial decisions of those prior judges and their rulings of case precedent. Other factors must be considered, and we're going to get into that. Number 9, an unconstitutional law, once enacted, has the force of law and will operate until it is successfully challenged. Court decisions based upon such a law can be overturned. The law itself may be repealed, removed, or struck down. The important consideration is, however, that an unconstitutional or unlawful law may exist unchallenged for long periods of time until they are successfully challenged. If they are successfully challenged. Sometimes laws that are actually unconstitutional go unchallenged. Now, I wrote a little post on this in Facebook. It's under code number 0112, and I had a little heading here called Constitutional Act, Not Law. Let's see. This is what I wrote there at the time. An unconstitutional act is not a law. It imposes no duties. It is, in legal contemplation, as inoperative as though it had never been passed. This comes from Norton versus Shelby County, Tennessee, 1886. It's a Supreme Court case cited as 118 U.S. 425, 442. I'm going to read it again because I didn't do that good of a job. I'm not satisfied with the way I read it. An unconstitutional act is not a law. It imposes no duties. It is, in legal contemplation, as inoperative as though it had never been passed. Again, Norton versus Shelby County, Tennessee. I have some brief commentary here. Bear in mind that to disarm the people, now I'm referring, I'm within the context of what we just read, I'm referring to the right to bear arms and the disarming of people. Bear in mind that to disarm the people, as is now being attempted in increments, is such an unconstitutional act. Be acutely aware that the constitutionality issue is not all. It also violates the pre-existing inherent and inalienable rights of the people, which existed before the American colonies, before the states, before the U.S. Constitution, and before the federal government. These are rights to self-protection through the holding and bearing of adequate arms that protect life, liberty, and property. Well, I said liberty, but also our freedoms and things like that. The issue of self-protection and of arms that we now face is the most important issue to come along probably in our lifetimes. All our other rights, freedoms, and liberties depend upon the people's continued ability to be armed. That, my friends, is self-evident, and if it is not self-evident, we are obligated with the duty, burden, and responsibility to make it so. Now, we're going to continue with this stuff of unconstitutional laws. Thus, in actual practice, an illegal law will be treated the same as a legal law. Legislative bodies may work to enact bad law, knowing them to be illegal, to serve some goal or purpose for a limited period of time. Of course, they would never admit that. Unfortunately, it goes along with the human tendency to do what they can get away with. Now, I want to interject here that we are in a sort of a unique time period where there's an uncommon amount of activity trying to bring in unconstitutional laws. And, the people are becoming numb to the idea and getting accustomed, conditioned to it. But don't get numb. Don't get conditioned. Don't get used to it. The government officials are sworn to uphold the U.S. Constitution. And that doesn't mean it's just a formality to get into office and then you can just do whatever you like. You know, we shouldn't get used to the idea that they're pushing unconstitutional laws and that are basically unlawful. So even though it's becoming commonplace, doesn't mean it's okay. These unconstitutional laws can do considerable damage and cause mischief until they are struck down. Such laws sometimes remain on the books, unenforced but not repealed. The legal system requires that bad law is challenged at some point within the administration, practice, and procedure of the law. Now, going by what I wrote in my little post in Facebook, it said that an unconstitutional law is no law and it has no force. But unfortunately, in actual practice, that's not how it works out. You see, an unconstitutional law that goes unchallenged continues to be treated the same as a constitutional law, and it can do a lot of damage and mischief while that persists. Okay, number 10. I wrote
Why is there that seemingly contradiction in terms there in that what you just explained? That on the one hand, they say an unconstitutional law is no law, but on the other hand, in reality, it has force of law until struck down or repealed.
Simply because that was the Supreme Court saying that an unconstitutional law is not a law. That really has no bearing outside the Supreme Court with police officers or attorneys or politicians going ahead and enforcing unconstitutional laws, you see. So, and of course, if it goes unchallenged, there is a system. The legal system sort of requires that when an unconstitutional law comes into law, the checks and balances is supposed to take care of some of this, and it has to be challenged. I mean, if the attorneys out there, the ones that practice law all the time, they're the ones sort of that it falls in their lap to challenge these unconstitutional laws. And they need to do that. Sometimes, though, even when they do challenge it, it's still, the unconstitutional law is still upheld in some courts. That's why we have an appellate system, so that you take it up to the higher courts. Now, if you take it all the way up through the courts and an unconstitutional law is still treated as a constitutional law, well, then you got a problem. Then you got a real problem. We rely on our legal system and the checks and balances to take care of these problems. And when it does not, then we have to regroup and figure out what to do. Okay, this one's important, number 10. I want you to really, really remember it. I'm not going to spend a whole lot of time on it. It's a detailed subject matter. So, like I said, this is it's such an intricate and important doctrine that it really needs to be addressed as a subject matter of its own. But listen carefully. Jurisdiction, once challenged, must be addressed. I'm going to read it again. Jurisdiction, once challenged, must be addressed. That's all I'm going to say about it for right now. Number 11. Case laws and precedents. This refers back to number 8 that we read earlier. Important. A judge presiding over and hearing an active case before him or her decides whether or not the facts and circumstances of the precedent case law being offered for consideration are sufficiently similar to the facts and circumstances of the case then before the court. Based on the presence of or lack of similarity, the court decides whether a case law precedent should be applied in whole or part to particular issues being litigated and adjudicated. Therefore, a case law precedent may have no impact at all on an active case. Now, I'm going to explain that one a little bit because people may not understand what I'm talking about. Okay, let's say that you've got a case before the court, and one of the attorneys, maybe the defense attorney, says, well, I've got this case precedent, Your Honor, that I'd like the court to consider, And in this case precedent, here's what it basically said. And the judge says, okay, well, that you're offering a case precedent. The judge, what he does is he says, well, in that case, the facts and circumstances were different than the facts and circumstances in the case now before me, and therefore I may or may not apply in whole or part that case precedent in this case. Or it could be the other way around. They say, well, yeah, that was the issue. The issues and facts and circumstances are called the fact pattern, you see. The fact pattern of the precedent case being offered was a certain way. And he says the fact pattern in the case now before me looks similar, but there are significant and major and differences, enough that I may not need to apply that case precedent to this case. So just because a attorney or a litigant even may offer a case to help himself out, or help out, if it's an attorney, to help out his client, does not mean that the court is going to have to apply it. The similarity of the fact pattern in the two cases is important. A lot of people don't realize that. It's mostly for legal professionals to, they of course know that, but the citizenry out there, sometimes they go, well, why didn't the case precedent apply? It sure looked to me like it should have applied. Well, that's why. Because the facts and circumstances were not the same, or not the same enough. Okay, go ahead.
A question about that. A
Yeah.
case precedent just means a decision by another court about similar circumstances and fact patterns, correct?
Right. Usually a case precedent like that comes from an appellate court of
Okay.
appeals. On appeal, the court will say certain things, and if it's reversed or affirmed or whatever. But I mean, like I said, the fact pattern is
So
important.
the case precedent comes from an appeals court, not just from another court.
Yes, usually it comes from an appeals court. You can cite cases that are trial court decisions as well.
Okay, so
But like I said earlier, one judge is not bound by the trial court decisions of another judge. So
right, particularly even if the circumstances were similar, if a judge in one case feels that the trial court made a poor decision in another case, he's not bound by that case precedent, right? Correct?
say it again.
Let's say you have a trial court decision from another court, and you now have a case where somebody's citing that as case precedent from the decision of this other trial court. Even if the circumstances are sufficiently similar, the judge is not bound by it if he feels that the precedent that was set in that other trial court was a mistake.
First of all, the one trial court judge is not bound by the decisions of another trial court judge.
Right.
We really should stick with appellate precedents.
So the only case
Yeah.
precedent they're bound by is appellate precedent.
They may or may not be bound by it. It depends on the similarity of the fact
if it's
pattern.
sufficiently similar.
Yeah.
Okay.
Yeah. And of course, if a appeal, let's say you have a case from a trial court goes to the first level of appellate court, and they don't like the decision that the appellate court made, well, you can appeal it up higher to the state Supreme Court, for instance. See, so the appeals process is there to take care of some of this stuff. The whole point of all that, what I said, was just because you enter a case precedent that an appellate court said, well, here's what it is, but the fact pattern of that case are really important. So I'm just trying to help people understand why sometimes case precedents have no effect at all on an active case before a trial court. Number 12, the Miranda decision for Miranda versus Arizona, 384 U.S. 463 491, which addresses the reading of the rights to a suspect during a custodial police interrogation, only states when a police officer or an agent of the police acting on behalf of law enforcement must, by law, inform the suspect of his or her Miranda rights. It does not in any way grant or deny such rights. The suspect is in continuous possession of his or her constitutional and lawful rights, regardless of the acts or omissions of the law enforcement officer. Example, you have the right to remain silent without the formality of the reading of the Miranda rights, because that right to remain silent is always yours. Therefore, when you are read your rights, it does not grant you a right or rights because you were already in possession of those rights. The Miranda decision is not about the granting of the rights you already had. The Miranda decision is a case which speaks to when the police are required to advise you of the rights you already have. That's what the Miranda decision is about. If you are not read your rights, it does not mean that those rights have been withheld, denied, or are inaccessible. If the police don't ask you any questions or do not interrogate you, they are not required to read you your rights just because they arrested you. Now, this is kind of interesting for me because sometimes I've watched movies with people who didn't know much about law, and then they said, hey, he didn't read him his rights. And then I said, well, they didn't have to. There's nothing happened that made it necessary for the police officer to do so. And a lot of people misunderstand how these rights work, and that's one of the reasons why I wanted to address this particular point, so that people understand that the reading of rights is just, the court just said, this is when we're going to require law enforcement officers to inform you of the rights you already have, because you may not know, you see. You may not know what your rights are. A lot of people do not have a good grasp on what their rights are. And of course, things like that can be subject to abuse by law enforcement. It's, I'm not pointing fingers or anything, but law enforcement abuses have occurred, as in any human endeavor. Sometimes there's abuses. It's nothing special for law enforcement. There's abuse going on all over the place. But these are just legal factors which protect people who don't know that they have the right to remain silent, who don't know that anything they do say can be used against them in a court of law, and all of the other factors that go into all this. It's based on that. I'd like to bring one point in. You've probably seen this in movies. You probably paid attention. Let's say the police have a suspect in an interrogation room. And then the next thing you know, a lawyer walks in who's going to represent the accused and the arrested person. And usually the first thing the lawyer says is, that's it, no more talk. Don't say another word. Now, think about that. There's a reason for that. All right, back to the main issue now. We're kind of leaving all those little legal points behind now and continuing on with the main issue. All right, still legal though. The subject at issue is the sovereignty or kingship of God. Many staunch believers in God understandably consider God to be their king and primary authority. The Bible indicates that we ought to obey God rather than men. This comes from Acts 5:29. When there is a clear conflict between the doctrines and laws of God and the doctrines and laws of men, we have a decision to make. We touched on this issue briefly earlier in the treatise. I wrote treatise because this comes from the treatise. As we know, the question of God's sovereignty has a direct bearing on the status of God's church. As a matter of doctrine, there should be no question, especially for remnant believers, that God is our immediate king. We owe him our full allegiance, loyalty, fidelity, and true, genuine, life-changing faith. Now we will consider the First Amendment to the United States Constitution. Did you have something? No? Okay. Let's take a look at the First Amendment to the United States Constitution. It begins with the words, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances." This was passed by Congress on September 25th, 1789, and ratified by 3/4 of the states on December 15th, 1791. Now, the 5 points, the 5 areas of law that are in the First Amendment, that even some lawyers can't, off the top of their head, tell you what the 5 points are, because they don't have to deal with it, probably. Point 1, the Religious Establishment Clause and the Free Exercise Clause. Point 2, the freedom of speech. Point 3, the freedom of the press. By the way, the freedom of the press is the only occupation directly addressed in the Constitution. Point 4, right of the people to peaceably assemble. Includes things they have serious concerns and grievances about. Because sometimes, especially in the old days, before television and before electronics and all that, that's how the people did it. If something happened and they had grievances and they were concerned about things, well, they would come together to talk about them and assemble to address that kind of thing. Point 5, the right of the people to petition the government for a redress of grievances. Those are the 5 points. Note also that in the line of the 10 Amendments, the right of self-protection by the keeping and bearing of arms was addressed second, denoting its importance. I wanted to go back here a little bit to the beginning of the Bill of Rights to begin with, is that the religion clauses happen first. That ought to tell you something about the weighty importance of our right and to have a connection to God. But the wording here, is not the way I would have written it. However, that's the wording we got, and I'll read it real quickly. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. It's 16 words in total. That's not that many words, people. As to the religion clauses, religion is a broad concept. Religion is like this wide. As to where believing in the biblical God and His Word is merely viewed in contemplation of law as just one of many religions. So we've got religion, and then we've got belief in the biblical God and His Word. It's not the same thing. See, they would never forget when you're looking at this through a legal lens, that religion means all those belief systems. That's what it means. It doesn't particularly pertain only to Christians who believe in the biblical God and His Word. And that makes a difference when you start working through what kind of access you have to that right to have a real relationship with God. Upon these 2 very brief clauses, specifically, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof. 16 words in all, 11 words if you eliminate Congress shall make no law. It's only 11 words. The founding fathers and the framers have hung our religious rights and freedoms. As we have already addressed and will continue to address as this study continues, the government has been able to place the church completely under man's sovereignty and jurisdiction. People believe that the First Amendment, as it is now written, fully protects their religious freedoms and rights. The fact is, however, that it doesn't. In actual practice, it doesn't in actual practice work that way. Exercising religion as now applied means that you have the right to believe in God, which is also called your right of conscience, and you even have the right to believe that the Bible is the inspired Word of God. Churches are allowed to exist subject to various secular laws, however. Generally speaking, if a church wants to be free from taxation, it must be incorporated under the secular laws of the state and must request tax-exempt status within the meaning of Title 26, Section 501c3 of the United States Code. That's the standard model of tax exemption church existence, or tax exempt church existence. That's a standard model that most churches fit into. Obviously, this church, the Remnant Church that I'm the pastor of, does not fit into that model because we don't have tax exempt status and we're not incorporated. Under this code, a nonprofit legal entity, like a corporation, a foundation, or certain trust, organized and operated exclusively for religious, charitable, scientific, testing for public safety, literary, or educational purposes as defined by the state, can apply for tax exemption. Pursuant to Section 508c1a of Title 26 of the United States Code, which are special rules with respect to Section 501c3 organizations, a legal church entity engaging exclusively in religious business and activities within the definition and guidelines determined by the state are granted the privilege of mandatory tax exemption. Now that's a kind of a strange phraseology. Granted the privilege of mandatory tax exemption. Well, it's mandatory. The word mandatory, when I first read that, I says, what are they talking about? It's a privilege, and now they're saying it's mandatory tax exemption. Well, the reason is that if you go back into history, when churches were co-sovereign with the state, and people understood that God was a separate sovereign, and he had a separate jurisdiction, and that man's law really had nothing to do with God's law, or shouldn't have power over it, churches were mandatorily tax exempt. They were tax exempt for other reasons than we would think they're tax exempt now. It is likely and probably certain, however, that an unincorporated church or an unincorporated association of religious believers would be denied the privilege of tax exemption. Incorporated churches, which are in reality legal entities created by the secular state through the Department of Commerce, and are engaged in religious business activity and commerce, as regulated by the state, must be represented by a licensed attorney who is a member of the state bar. Thus, the secular state grants permission for a church to exist as a legal entity. It is then entitled to state-granted privileges and immunities. As I stated before, a corporation is a creation of the secular state. It exists only in contemplation of law. Man's law, that is. The state regulates and controls such legal entities and at the same time regulates the licensed attorneys under threat of disbarment that represent those entities. Now, when I say under threat, they're not always being threatened with disbarment. What I mean is if they step outside the parameters of their practice, of their legal boundaries in which they practice law, they can be subject to disbarment. Needless to say, the state is also empowered to investigate the business and activities of all state-created legal entities. So basically what I'm saying there is that when a corporation is a creation of the state is of course empowered to investigate those entities which was created by the state. And that applies also to religious and ecclesiastical entities which become an ecclesiastical corporation. Just because it's an ecclesiastical entity doesn't exempt it from being investigated and controlled by the state. When applied to a religious entity, this is loosely termed freedom of religion and a system of free exercise of religion. Even though the First Amendment states Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, there are numerous laws which take jurisdiction over and in actual practice regulate and control religious entities. Moreover, in actual practice, The unfettered, free, and full exercise of religion is ultimately prohibited. Never lose sight of the fact that it is the secular state that determines what the free exercise of religion legally means. See what page I'm on? Oh, okay. The sovereignty of man is the real power over the churches, and it is that jurisdictional power and authority that weighs the scope of church actions and privileges against the public policies of man and the interest of collective society. The word policy derives from the same word as police, and it relates to the word political. They are all based on the Latin and Greek usage polis, which refers to a city that has established a form of government for the benefit of its people or citizens. By extension, polis and pole expands its meaning and application to include a city, a church, a state, a nation, or even a global system of government. Likewise, the words state and status are related in usage and meaning around the concept of state of being and or status in a form of being. The word public comes from the Latin publica, referring to the collective members of society which form, at least in the United States and in other democracies, the sovereign body politic. Thus, the collective members of society, through their representative government, police the status, privileges, immunities, and religious actions of the legal entity created by the secular state, operating as and engaging in the business of religious activity under the name and title of church. Now, the reason, this is kind of phraseology. I wanted to make sure I said it the right way. But basically what we're saying is that when a state creates a corporation, which is a creation of the state then, and even if it's an ecclesiastical corporation, it's regulated by the state, it's under the jurisdiction and sovereignty of the state, and it is not actually a church, even though it has a corporate name, church. It is no longer under God, it is now under the state, and yes, it is involved in religious activity and commerce. Yes, it is called a church, but in actual fact, especially as it relates to the Bible, that's not a church. That's a creation of the state, existing as a corporation, engaging in religious activity and commerce, non-profit with tax exemption in a perfect world, with the name and title church. And that's kind of a circuitous way of explaining it, but I want you to, again, look at it jurisdictionally. Look at it through the lens of law, and you will see that that's what it is. Now, I don't blame people for not understanding that. People, the clergymen are just trying to teach God's word and get people closer to God. The congregation is just trying to learn God's word and get closer to God. They didn't know all these legal ins and outs and all of the tentacles, the jurisdictional tentacles of secular government that wrapped around this whole concept and reality. They didn't know that. I'm revealing it to you now so that you will see, so that we can see where the problems began. That's why we called this series of videos, we called this the biblical and legal status of the church under God. Okay, next I wrote important again. In nearly every case across the board, God's temple and house of worship has been reduced to a mere state-created legal entity engaged in tax-exempted and regulated religious commerce. Freedom of religion, outside of the meaning of freedom of every kind of religion, is, like the separation of church and state, a myth. I'm going to read that first part over again. That's why I wrote important here. It is important. Maybe I'm reading too fast. I don't know. In nearly every case across the board, God's temple, it's his temple and house of worship, God's temple and house of worship has been reduced to a mere state-created legal entity engaged in tax-exempted and regulated religious commerce. I want you to process that through your mind. I want you to, even if you have to stop the video for a minute and think about what we just said, so that it registers and it penetrates, because these are truths you're probably not going to hear anywhere else. We should carefully take note of the fact that the First Amendment limits its religion clauses to the Congress of the United States. It states that the U.S. Congress shall make no law respecting an establishment of religion or the free exercise of religion. Strictly interpreted, there is no statement that imposes those limitations on the individual state legislatures, because it says Congress. And originally, the Bill of Rights applied only to the federal government, by the way. That was confirmed in the case of Barron versus Baltimore. That's not the subject, but I just wanted to mention that. Thus, the great majority of laws which regulate and control corporate churches are enacted primarily through the legislatures of the individual states. Now, I want to tell you this, though. After the Constitution was ratified and the Bill of Rights came in, and of course it wasn't applicable to the states yet, it was only applicable to the federal government. Like the Second Amendment was not immediately applicable to the states. That didn't even happen until 2010, when it was applied to the states, the Second Amendment. But anyway, then after the Civil War, the 14th Amendment came in. Then that's when the doctrine of incremental incorporation of the Bill of Rights upon the states became possible and began to occur thereafter. Then various parts of the Bill of Rights were applied to the states. That's why I used the phraseology incremental incorporation, because it does it in increments. Now, various attributes of the First Amendment religion clauses became applicable to the states and the churches in the states and church-state relations. However, I want you to remember this. It is always within the conduit of those 11 words, 16 if you take the first 5 words, 11 words where it hangs our connection to God and His Word. It always comes back to that, you see. It always comes back to that. And a lot of people miss that. A lot of people don't understand. So even if it is applied to the states, and some of it has been applied to the states, that's true, then it still comes back to those 11 words. And it still doesn't do anything about getting you outside of the constitutional construct, which doesn't allow you access to the sovereignty and jurisdiction of God, nor does it allow you access to the jurisdictional authority of His Word. It's always within that constitutional conduit and those 11 words that they hung all of our relationship to God and His Word to. All right. Let me, I think there's an important point here that's coming up. Let me look. Yes, the legality of this practice is bottomed on the doctrine that the federal government allows and recognizes the qualified and limited sovereignty of the individual states to regulate and control all legal entities, including their activities, operating within its jurisdiction. Now, this is an interesting point here. Judge Napolitano, some of you may know who he is, has stated that at this point, the word Congress in the phrase Congress shall make no law in the First Amendment can be applied to mean government, so that it may be understood as government shall make no law. It's not just Congress.
Did he mean by that all government, state or federal, or state and federal?
Government, all government. Let's see, got some things here in my footnotes. The sovereignty of the individual states is not at this point in history a true unfettered sovereignty. Over time, state sovereignty has, in increments, been diminished and disparaged. In 1778, by way of the Articles of Incorporation, Articles of Confederation, creating a confederated union of sovereign states, the individual states entered into a compact of confederation which still recognized that each state retained its full sovereignty. Then in 1787, the states entered into a national compact called the Constitution of the United States. By doing so, the states acquiesced some of their powers to the national government. Now, there's an interesting point to all of this. Originally, after the Articles of Incorporation were in place, the idea was, after the Revolutionary War was over, was to just modify the Articles of Confederation to fit the new liberated people of the United States and to form the country. They said, well, we need to, in order to make a united confederated union of sovereign states, we need to change the Articles of Confederation a bit. But that was the original idea. That did not go through. What happened was they set aside the Articles of Confederation, and in the Constitutional Convention, and where they drafted the Constitution and considered everything, they just came in with a new Constitution rather than modifying the Articles of Confederation. So that's what happened when the Constitution came in. Okay. Let's see. The full impact after the Constitution came in of that compact was not fully realized for about 60 years. In an attempt to regain its true sovereignty and rights, like it was under the Articles of Confederation, the Confederate States of the South formed a separate confederation and the Civil War began. That's when they seceded from the Union. Finally, after the war, the National Compact was replaced by a Federal Compact founded primarily on the 14th Amendment in 1868. That resulted in a further loss of true state sovereign power. Thus, the states and the people pass through another legal membrane. That's how you can think of it. Each time you pass through a legal membrane that changes things. So first there was the Articles of Confederation, which was just basically a confederation of fully sovereign states working together. Then they passed through the legal membrane of the Constitution of the United States. That changed things. In actual fact, the states acquiesced some of their sovereign power to a national government at that point. Then after the Civil War, it changed again through the 14th Amendment, another legal membrane, and it changed again. A further loss of sovereign state power occurred. Okay, let's see. The states over time have been absorbed into the federal system and power structure by various means of control, to a point that moves ever closer to only a figurehead of true individual state sovereignty, freedom, and independence remains. Another footnote here. Within the various parameters specific to each situation, federal entities, government and semi-government, are jurisdictionally immune from the powers of the state in which it is located. Here again, it involves a competition of sovereign powers operating between the federal and state jurisdictions. So you've got two sovereigns there. Of course, all these states they all have some sovereign status and power. But if you have just one state and the federal government working, it's a competition of federal and state jurisdictions. In some instances, the federal and state powers cooperate to apply a species of joint jurisdictional effort. It is not an intermixture of jurisdiction, however, but rather a case of two separate jurisdictions working and harmonizing with each other. In actual practice, federal jurisdiction is clearly the more powerful and ultimately, although not in all cases or instances, legally dominating. The notion that federal power is growing bigger and bigger, of course, it's not that difficult to see that for yourself, that's what's going on, and that the states are resisting that trend to a certain extent, unless when they don't want to resist it. The states are resisting that trend because they feel, and rightly so, that they're losing some of their power that the federal government is taking. And the states, people in any form, individual people, groups of people, whatever, once they have power, people don't generally want to lose it. You see, so it shouldn't surprise anybody that when the states see that things are moving in the direction of states losing their power, they're going to resist it. They don't like that. And the federal government, when they sense that they're gaining power, well, they're going to want to gain more. It just seems to be human nature. And government, let's be clear on one thing. Government is just a group of people. It's not chimpanzees or cocker spaniels making up government. It's people. Okay. That, by the way, let me add a little twist to that. It's people just like you and me that have no more rights and powers that they were born with than you and I. We can readily discern that corporate churches are entities which have been incorporated or brought into or made part of and absorbed into the sovereignty and jurisdiction of the secular state. To incorporate comes from the Latin corpus, meaning body. Hence, legally, when a church incorporates under the laws of the secular state, it is brought into and joined or yoked with the one body of the state. It is, in fact, a legal creation of the state. And of course, that goes directly and diametrically opposed to the idea that some people have about separation of church and state. It is not a separation of church and state. It is a fusion of church and state, and it is a situation where the state is the more powerful in the component in the fusion, and also the one that controls jurisdictionally and by sovereignty the church. I know that's hard for some people to hear. I'm sorry I have to put it in such blunt and direct and maybe offensive manner. I'm just telling you what the law actually, how the operation of law actually comes together, how it actually works. Under man's law, a corporate entity is a legal person but not a citizen. It is nothing even close to the status of a church established under the sovereignty and jurisdiction of God. The likely reaction of the secular state to a true church of God would be non-recognition and rejection as to its status as a church and as an entity with separate legal rights under God. That's another thing about humans. Once they have control, they don't like to give that up either. Okay, here again, the real issue with which the secular state takes exception is its lack of ability to legally control and regulate jurisdictionally separate religious entities. And also, historically, because of misconduct of churches in the distant past, the idea is, well, if we don't control and box in these churches, what will happen then? They'll get out of hand, and I've addressed different aspects of that view of things in my writings and in the videos. I really think it'd be wise for you to look at all the videos I make and give it some real thought and consideration. One of the most powerful tools at its disposal over corporate churches is the ability to threaten the denial and removal of tax-exempt status. as well as the withdrawal of a license to perform and solemnize civil state marriages. By somewhat the same principle, the state can disbar attorneys, thereby tightly controlling the privilege of practicing law and, by extension, the legal representation of religious entities. Remember, a corporation must be represented by an attorney of the bar. To put it bluntly, the secular state controls the churches and the people that legally represent the churches. Thus, the secular state blocks the true kingship of God over the church and over church members. Another important that I typed in here. What did I have to say? Okay, let me read that one. Access to the courts on issues involving God's status, sovereignty, jurisdiction, as well as church rights under God, the authority of God's word, and the legal representation of God, his church, his word, and his believers are all very carefully denied, controlled, in specific areas excluded, and limited. That's a mouthful. Do you think I need to read that one again? Yeah? Let me read that one again. Maybe slower. Access to the courts on issues involving God's status, sovereignty, and jurisdiction, as well as church rights under God, the authority of God's word, and the legal representation of God, his church, his word, and his believers are all very carefully denied, controlled, in specific areas excluded and limited. That's a lot. There's a lot in that. You know, you need to think about some of these things. I said, don't watch these videos just once. Watch them all the way through. I know some of them are long. Watch them all the way through. Set it aside. Take a week, 10 days, whatever you need. Watch it again. And, you know, until it really starts to register and penetrate. There's a lot of years went into collecting this information and researching it, and now that I present it to you, you know, I hope you don't take it for granted. A big chunk of my life went into being able to do what I do now. I started this when I was just over 30 years old. I'm 65 now. Thus, in actual practice, when a church is represented by a licensed attorney of the bar, the right legal issues truly addressing God's jurisdictional matters have little or no chance at all of ever being heard, let alone adjudicated. The courts, the judges, and the attorneys are not empowered to go beyond the legal barriers which keep God's sovereignty well out of reach. Remember those 11 words, 16 if you count Congress shall make no law. That's where everything hangs, right there. And of course the solution to it is to get beyond those 16 words. And I will be talking about, you know, how that can be done. You have to look at it the right way. It's the same thing, by the way, with the Second Amendment. The right to keep and bear arms didn't come from the Second Amendment. The Second Amendment does not grant the right of self-protection and the right to keep and bear arms. Your right to keep and bear arms is not a constitutional right. It is an inherent, inalienable, pre-existing right. Okay, we will address how we can access God, his word, and his church as our study continues to unfold. Be aware, however, that it has taken many years of prayer, study, research, and testing, over countless hours of painstaking labor and struggle, often without results, to reach some of the truths, answers, and solutions. We must set the record straight once and for all that God's true church must be established under his sovereignty and jurisdiction, and, key statement is coming, it is exempt from secular taxation as a matter of jurisdictional right under the sovereignty of God. I'm going to read that over again. It's that important. We must set the record straight once and for all that God's true church must be established under his sovereignty and jurisdiction, and, key statement, it is exempt from secular taxation as a matter of jurisdictional right under the sovereignty of God. Let that one penetrate, please. It is not tax exempt based upon a state-granted privilege or state-granted immunity. Now, when I say the state, I don't mean just the state, individual states. I mean the state of secular man's laws, of federal and everything. Okay. It is not tax exempt based upon a state-granted privilege or state-granted immunity. It is jurisdictionally and lawfully immune from state taxation. Nor should the secular state regulate the free exercise of God's doctrines and related activities. Key statement: that guarantees that the pulpit can stand as a true platform of God's Word, free from the pressures that come from being legally beholden to and dependent upon the secular state. Thus can God's truth, righteousness, and justice be sounded from His true church, unfettered by secular control, coercion, pressure, and influence. Therefore, no matter how accommodating or workable state-granted tax exemption may be, through laws such as Section 501c3 and Section 508c1a of Title 26 of the U.S. Code, it still flows from the secular jurisdiction of man. Hence, it is better not to have the privilege of secular tax exemption and strive to be under God, free to proclaim the fullness of God's truth and the Word. Now, here comes the cautionary implementation clause that I often say when I did my disclaimers. From time to time, I make cautionary statements. This is one of them. Listen carefully, please. I am not suggesting that any clergyman or church should immediately implement these truths upon initial discovery. Now is the time for study, research, and evaluation. Putting these truths into actual operation must be carefully considered. Training on how to proceed and how to navigate through secular authority is necessary. However, make no mistake, to return to the sovereignty and jurisdiction of God, thereby changing the status of the church and its clergymen to what it and they doctrinally must be, is absolute. This is part of the requisite action which will ultimately protect the remnant. The remnant, I mean the prophetic remnant spoken of in the Bible, from the jurisdiction of the prophetic beast. Let me read that again. I know this is hard-hitting stuff. It's abrupt. It's direct. I don't know any other way to teach it, actually. This is part of the requisite action which will ultimately protect the remnant from the jurisdiction of the prophetic beast. This principle can clearly be seen and understood when we address holy matrimony under God. Now I'm taking a little slice of something to show you the stark. You'll be able to look at this and say, yeah, there is a problem, jurisdictional problem here. Remember the jurisdictional lens. Look at things through the lens of jurisdiction. We have to think jurisdictionally. Just like Emmett Brown told Marty McFly, if you're talking about time travel, you have to think fourth dimensionally. And Marty McFly says, yeah, I got a problem with that. I don't forget to do that. Holy matrimony under God, which no man can put asunder. Let me just start that from the beginning. This principle can clearly be seen and understood when we address holy matrimony under God, under God's jurisdiction that is, which no man can put asunder, as stated in Matthew 19:6 and Mark 10:9, as opposed to a civil state licensed marriage, which is a mere legal relationship controlled by man's secular jurisdiction and sovereignty. There's a difference. Holy matrimony under God is one thing. Civil state marriage under man's jurisdiction, which you have to get a license to do, and which you have to have a clergyman get a license to solemnize, is something entirely different. The stark difference between the two jurisdictions is clearly apparent there. As I stated before, in order for a religious official, such as a pastor, priest, or minister, to solemnize and legalize a state marriage, He needs to be empowered and authorized by a state license. License is permission to do that which would otherwise, without the license, be illegal. By legal definition, I just read that, so I can skip that part. All right. It is a secular right or privilege to enter into a legal union recognized and controlled by the state. Be aware that the state has created a legal condition in which it has made it illegal for a clergyman to solemnize and legalize a civil state marriage without the permission or license of the secular state. Therefore, it requires a license to get married. That's what, the standard marriage license. And it requires another license for the existence of authority, outwardly ministerial, pastoral, and clerical, to perform a civil marriage. Completely and totally and utterly jurisdictionally controlled under the sovereignty of man. Note, a secular judge or a justice of the peace can perform a state civil marriage as well. They're not ecclesiastical. They're not under God. Therefore, licensed clergymen are acting as a secular agent of man's law, not God's. Thus, here again, important again, I wrote important. God's institution of holy matrimony in secular jurisdiction has been reduced to a civil marriage contract which regulates property issues, the privileges governing custody and control of the children arising under the marital agreement, access to state benefits and privileges, such as marital tax benefits, and the commercial advantages involved in the business and legal activity of marriage. You have to look at it through a jurisdictional and legal lens, and you'll see things that you didn't see before. Here again, somewhat akin to corporate churches, a state marriage is entered by and through a marital compact, which is a binding contractual agreement involving three parties, namely the two spouses and the secular state. See, there's three parties involved, the man and wife in a perfect world and the secular state, to engage in the business of marital activities and commerce, which the state regulates and controls. The state gains jurisdiction and control over the benefits or increase of the marital business, which is the issue, children arising therefrom, pursuant to the legal doctrine of parens patriae, which I will talk about a little later. This jurisdiction is gained at two distinct levels. First, by way of jurisdiction through birth under the 14th Amendment. Second, by way of its status as the third and most powerful party in the marital compact. Moreover, applying for a license is, in effect, your request to have the proceedings placed under secular jurisdiction. Be acutely aware that the jurisdiction exercised over you, your marriage, and your children comes from you. Remember when we were addressing those points in the Big Four? All the jurisdiction that'll be exercised over you comes from you. Individual, joint, or group ignorance of the law notwithstanding. Thus, the institution of state marriage is clearly controlled as a commercial activity without regard to the religious nature, outward appearance of it, of the union. When a secular court judge performs a civil marriage, she or he is not at all acting in an ecclesiastical or even a quasi-ecclesiastical function or manner. On the contrary, they are acting as an official of the secular state to which they are jurisdictionally bound. The Bible makes reference to the way the world has a tendency to view people as merchandise, human resources, or commercial products. Footnote, here's where I deviate a little bit, and I want to talk about parens patriae for a minute. That's, of course, Latin, parens patriae, is the Latin for and means parent-father. In actual practice, the secular state is the controlling authority over the children of a state marriage, acting as the jurisdictional parent and father over their health, safety, and welfare. That power is superior to that of the actual biological and or legal parentage of husband and wife. The state can also exercise powers which require that the children are educated according to state-approved curriculum. It can even determine how much power the spousal parents have over the medical issues and the religious rejection of medical care of the children. Hence, the secular state is the final controlling parent and father of the marital children. Thus, as a matter of law, the secular state, not God, is the sovereign over the marriage and the marital children, and it has jurisdiction over husband, wife, and their issue. I know this is hard-hitting stuff. I'm sorry if it hits you that hard. I tend to think, I've been at this for a long, long time. I tend to think in unemotional legal terms. And a lot of people say, boy, he sure is hard the way he says things and expresses it. Yes, it looks that way. Don't make no mistake. It's not that I don't care. I do care. But I don't, like I said, in order for me to get the information out to you the right way so that you can grasp, so that you can see, so that, as Gandhi once said, Mahatma Gandhi said, make the injustice visible. That's what we're doing here. We're making the injustice visible. In the Bible, it says that a lot of people do not have a grasp of the key of knowledge. I'm giving you back the key of knowledge. That's what I'm doing here. And I hope I'm doing an adequate job. Now, in the book of John, chapter 2, this is where we're going to talk about making merchandise of people, treating them as commercial products, as human resources. The Bible does actually speak to these things. In chapter 2 of John, verse 1, "But there were false prophets also among the people, even as there shall be false teachers among you, who privily shall bring in damnable heresies, even denying the Lord that bought them, and brought themselves to swift destruction." Be sure, especially as believers, don't deny the Lord that bought you. And then created you, and bought you with his very life, so that you could have redemption from sin. Upon themselves swift destruction. If you deny the Lord, you bring upon yourself swift destruction. Verse 2, "And many shall follow their pernicious ways, by reason of whom the way of truth shall be evil spoken of. For example, such as speaking out against abortion, it shall be evil spoken of." Clearly, the Bible does not endorse abortion. Now, I'm not going to go into the abortion issue here now. I made a video about it. I suggest you go watch the video that I made about abortion. But it says here, "By reason of whom the way of truth shall be evil spoken of." Boy, is that ever happening today. When you talk the truth, like I do and others do, it's evil spoken of. It is not well received by the world. Verse 3, "And through covetousness shall they with feigned words make merchandise of you, whose judgment now of a long time lingereth not, and their damnation slumbereth not." See, with feigned words they shall make merchandise of you. This is what the Bible is telling us. Verse 16, "And he said unto them that sold doves, Take these things hence, and make not my Father's house an house of merchandise." Key thing here, make not my Father's house. It's God's house. It's supposed to be under his jurisdiction, under his sovereignty and kingship. He says, make not of my house a house of merchandise. Okay, let's go now to Revelation 18, verse 12 and 13. "The merchandise of gold and silver and precious stones, and of pearls and fine linen, and purple and silk and scarlet, and all thyine wood, and all manner of vessels of ivory, and all manner of vessels of the most precious wood, and of brass, and of iron, and of marble." Then verse 13, and cinnamon, and odors, and ointments, and frankincense, and wine, and oil, and fine flour, and wheat, and beasts, and sheep, and horses, and chariots, and here it comes, and slaves, and souls of men. Now here's what I wrote in relation to those verses. Revelation 18 verse 12. This is a verse primarily a list of merchandise which collectively means the riches and wealth of the earth. Revelation 18 verse 13. This verse is a continuation of the list of riches and wealth of the earth with two important additional items. The first refers to slaves, which means that the merchants of the earth have made merchandise of men and converted them by way of various legal practices and procedures into resources, servants, and slaves. One of the ways they do that is through a system based on overwhelming debt. Debt translates into control and servitude. The second refers to the souls of men and is a reference to the fact that in order to be part of their system of commerce and prosperity, you must in essence sell your soul to them. For many, money, riches, and wealth become the object of life above all else. It is in fact a form of worship at the altar of monetary and material gain, with greed as its main pillar of belief. The system is tailored so that you become willing to do whatever it takes to prosper yourself. You know, I've heard this before, and they say, this is what you've got to do to be successful. Well, be careful with that. This is what you've got to do to be successful. Depends what they want you to do, doesn't it? Hence, the merchants of the earth, often gaining the support of many in power, government and private, in essence engages in the commerce of human beings, human resources, in actual practice making merchandise of them, as well as trafficking in men's souls through the conversion to a religion of greed and wealth. Okay, here's where we're going to, this is the end of part 4 of the treatise that I wrote. All of this that we covered was covered in part 4 of the treatise on the biblical and legal status of the Church of God. We're going to go on, however, before we close out this video. As to the issue of inherent rights that I often address, which includes pre-existing, inherent, natural, human, and God-given inalienable rights, as well as what the late Supreme Court Justice Antonin G. Scalia termed pre-political rights in the case of D.C. versus Heller, a 2008 case, cited as 554 U.S. 570, I want to stress again that your inherent right to have a real relationship, which is a genuine relationship with the biblical God, including access to his sovereignty, jurisdiction, and kingship, also encompassing the legal jurisdictional authority of his holy word, which is God in written form, as reflected in John chapter 1, verse 1 through 4, is the highest inherent and inalienable right you possess. I'm going to read part of that again. I want to stress again that your inherent right to have a real and genuine relationship with the biblical God, including access to his sovereignty, jurisdiction, and kingship, also encompasses the legal jurisdictional authority of his word, which is God in written form, as in John chapter 1, verse 1 through 4, is the highest inherent and inalienable right you possess. I also want to stress that you, of course, have other inherent rights, which I often address in my writing and videos. With all that in mind, see, it's not just what I'm getting at is it's not just that you have a right to a real relationship with the sovereignty and kingship and jurisdiction of God and with the legal authority of his holy word, but you've got all of these other inherent rights. I have a video on inherent rights, which, if you get a chance, you can go to Facebook and look that one up too. Okay, now, With all that in mind, I am specially going to address what Sir William Blackstone, a famous English jurist who lived from 1723 to 1780, had to say about such rights. This is under in his set of writing called Blackstone's Commentaries. Under the right of persons, I took this from volume 1, page 121. Okay, he says, I have it right here. This is volume 1 of Blackstone's Commentaries. Right here, it's a book that many lawyers have referred to over time. It's still in the old writing where the S's look like an F. All right, Blackstone's Commentaries. What did Sir William Blackstone have to say about this stuff? Let me read it to you. The absolute rights of man, considered as a free agent, endowed with discernment to know good from evil, and with power of choosing those measures which appear to him to be the most desirable, are usually summed up in one general appellation, and denominated in the natural history of mankind. This natural liberty consists properly in a power of acting as one thinks fit, without any restraint or control, unless by the law of nature, being a right inherent in us by birth, and one of the gifts of God to man at man's creation, when he endued him with the faculty of free will. What's interesting about this is the wording that he uses. He calls them the absolute rights of man. And I had not considered using that terminology before. I was calling them inalienable rights. I was calling them inherent rights. And it's okay to call them by those other names. I was calling them human rights. I was calling them natural rights, pre-existing rights. Justice Scalia called it pre-political rights. But here he uses the wording, the absolute rights of man. Okay. I'm going to read here. Well, there's another part I probably should talk about. Notice where he says this natural liberty, he uses the term natural liberty, consists properly in a power of acting as one thinks fit, without any restraint or control, unless by the law of nature. Now, in the Declaration of Independence, see, he's referring to natural liberty. This is what in my list would be called natural rights. He says natural liberty, and he says unless by the laws of nature. Now, in the Declaration of Independence, Thomas Jefferson used similar wording to that. And I'm going to read it to you. I have it here in a booklet. Let me read it to you. This is, of course, from the Declaration of Independence of 1776, codified in the United States Code at this point. It says, this is from the very beginning of it, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature, here's when it comes, the laws of nature and of nature's God, again, this is coming straight out of Blackstone's Commentaries, and of course, if you go back all the way back to Thomas Aquinas, entitled them a decent respect to the opinions of mankind requires that they should declare the causes which impelled them to separation. This is when they were telling the British, you're not treating us right as colonies. You're abusing your positions, and it is impelling us to separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. These are very important words, especially where it says deriving their just powers from the consent of the governed. We need to consent to the way we're governed. And remember when I said to you, I said, all the jurisdiction exercised over you comes from you. You consented to what's happening. You consented. Maybe you didn't know that. You back engineer it, it falls back on your consent. And it could be presumed consent. It could be because you failed to object in a timely manner. They assume and presume consent. And until you tell them in a timely manner that you object to it, they assume that you're saying it's okay. That you're saying it's okay. But what's interesting here, when I first read this years and years and years ago, where it said in the Declaration of Independence as laws of nature and nature's God, I wondered for a minute. I said, what does he mean, nature's God? I don't know exactly what that means. I know what the biblical God is. I know what the Bible is, but this term, nature's God, I wasn't sure what that was. And he refers to the laws of nature. This is directly, you can associate that to what Blackstone said in his commentaries. Now we're going to analyze it a bit, okay? Before I do that, though, I will continue to read what Blackstone said just after the commentary I first read above, lest someone would say I tried to hide what he also said. See, I don't want to do that. I don't want to give you just the part that sounds good and then try to hide the part that came after that didn't sound good. Now in the law, various attorneys realize that if something bad is going to come up, it's better if you bring it out first than you wait for your opposing counsel to bring it out and make you look bad. So I'm not going to do that. I'm not going to wait until somebody says, yeah, but Pastor Mike, you didn't read what came right after that. You only read the good part. You didn't read the part after. So I'm going to read the part after right now. But every man, when he enters into society, gives up part of his natural liberty as the price of so valuable a purchase, and in consideration of receiving the advantages of mutual commerce, obliges himself to conform to those laws which the community has thought proper to establish. And this species of legal obedience and conformity is infinitely more desirable than that wild and savage liberty which is sacrificed to obtain it. For no man that considers for a moment would wish to retain the absolute and uncontrolled power of doing whatever he pleases, the consequence of which is that every other man would also have the same power, and then there would be no security to individuals in any of the enjoyment of life. Political thereafter, or civil, liberty, which is that of a member of society, is no other than natural liberty so far restrained by human laws, and no farther, and is necessary and expedient for the general advantage of the public. Okay, a lot going on there. We're going to analyze it. All right. The part where it says natural liberty. Well, it's not just natural liberty. You see, we don't just behave because we're part of nature and nature's God. Natural liberty may be what some people would think it is. Well, in nature, you'll just go, there'll be chaos. There will be misbehavior. There will be injustices. As he says here, there wouldn't be any protection for the enjoyment of life. There'd be no security. Let's address that for a minute. He says to enter society, we must give up part of our natural liberty. This ought to tell you immediately that it's voluntary. You're giving up part of your natural liberty. Even if you were going to call it just natural liberty, you're giving it up voluntarily. You're consenting to it. That's something that you shouldn't miss. Short analysis. Here's what I said. For every man gives up part of his natural liberty to enter society in consideration of receiving the advantages of mutual commerce, which obliges him to conform to those societal laws. So it was voluntary. That species of obedience and conformity is, Blackstone writes, infinitely more desirable than the wild and savage liberty which is sacrificed to obtain it. All right, let's read what I commented here. That may be argued to be true if it is based only upon the laws of nature and nature's God, as he, Thomas Jefferson, had written, but it must be carefully distinguished from liberty under God, based upon his rules of conduct and behavior, which does not endorse a wild and savage liberty. Thomas Aquinas and Blackstone refer to the deist version of the laws of nature, where nature's God is reported to allow mankind an unrestrained and uncontrolled existence of wildness and savagery. That is not the methodology of the biblical God. So we have to go beyond just nature's God and the laws of nature. For no man that considers for a moment would wish to retain the absolute and uncontrolled power of doing whatever he pleases, the consequence of which is that every other man would also have the same power, and there would be no security to individuals in any of the enjoyment of life. Okay, I commented this way. First of all, we do not seek to retain absolute and uncontrolled power of doing whatever we please, nor does God's word endorse that. We do not seek that model of the absolute rights of man. No, we seek to return unto the sovereignty and jurisdiction of God and the jurisdictional authority of his word, so that we may exercise our absolute right to have God as our actual king in a controlled system of conduct and behavior where a man cannot do whatever he pleases, in an unrestrained and uncontrolled existence of wildness and savagery. God doesn't endorse an uncontrolled existence of wildness and savagery, does he? People who know the Bible know that that's not the case. There is, therefore, no reason to conclude that the security of life need be sacrificed. Finally, the last part reads, political thereafter, or civil, liberty, which is that of a member of society, is no other than natural liberty so far restrained by human laws, and no further, as is necessary and expedient for the general advantage of the public. You see, let's get one thing straight. They're kind of in a roundabout way arguing that your inherent and natural rights are not preferable to the control, where you have less rights, of society. Well, that's just simply not true. That's just simply not true. And you can see that today if you just look around and are able to contemplate clearly what you see. More, let's see what I wrote here. This is political and civil liberty as a member of secular society has broken down. Is no other than natural liberty, so far restrained by human laws, and no further, as is necessary and expedient for the general advantage of the public. Let me see, I lost my place here. It has broken down before our eyes, okay? The secular society has broken down and is breaking down before our eyes to the point of deprivation of basic inherent rights and incremental deprivation of such rights beyond just the liberty and restraint by human laws as is necessary for expedient and the general advantage of the public. Moreover, not only are we having to deal with agendas of infringement and predation of our basic inherent rights, but the standard that Blackstone focuses upon is the general advantage of the public. Unfortunately, the general public's wants and desires, through some theory of majority rule, inconsistent with God, has every potential of implementing a public-based paradigm of tyranny upon the individual rights of those who do not consent thereto and opt to preserve their rights under God, so that they can have him as their sovereign and jurisdictional authority, together with access to obedience to his biblical directives required for avoidance of the sin and iniquities of the world gone far astray from God. That, my friends and brethren, is for the general advantage and deliverance, not of the public, but for the general advantage and deliverance of God's people. Do you have anything you want to bring up? No? Okay. So, I kind of want to talk about this a little bit. This idea that it is preferable to give up our inherent and inalienable rights under God. It's preferable to do that and acquiesce to the control of society. That's what they're saying. It is not preferable. And when things start to break down and the will of the people goes far astray from the will of God, it really starts to become problematic. And that's why we're dealing with what we're dealing with now. We just see a world that's following the drum of their own wants and desires, seeking their own destiny free from God and his truths, reversing God's truths at every turn, and calling things that are absolutely not right, calling them right, and calling things that are absolutely right not right. All of those things come from a public and human society under man's sovereignty and jurisdiction gone wrong. And at that point, as long as we didn't reach the critical point where it got to be to the point where we could no longer go along with it, then that's when the Bible says in Revelation 18:4 and 5, "Come out of her, my people, come out." And he's calling you, of course, my people. You're my people. I'm your king. I'm your sovereign. You're under my jurisdiction. Come out. It's too late. It can't be turned around. That's basically what it says. There's a lot of people running to and fro right now saying, we can straighten this out. We can fix this. Yes, it's gone a little crazy, but maybe we can still latch onto it and turn it right again. Well, that's not what the Bible says. The Bible says, "Come out of her, my people." Think about that phrase jurisdictionally, not just like reading a novel. Come out of her, my people. It says, come out. It's too late. For her sins have reached unto heaven. The iniquities and the sins have reached unto heaven, and it's too late to try to fix it. It also says later on in Revelation, let him who is evil, let him remain evil. Let him who is not evil and is righteous, let him remain righteous. It's too late to change it. It's gone too far. It's gone too far. And I'm sorry to report that I have to report that to you and say that, that's the situation. But that's the situation. It's not only reality, it's prophetic. And we're just going to have to deal with it. We're just going to have to deal with it. And sooner or later, if you don't pay attention to these warnings and you stay in society and you go along with what's happening, pretty soon you'll have the mark of the beast. And then you'll still be buying and selling. And as it says in Revelation 13, if you have the mark of the beast, if you don't take the mark of the beast, you won't be able to buy or sell unless you have the mark of the beast. Then in Revelation 14, verses 9 through 11, there are severe penalties for taking the mark of the beast. So if you want to avoid those penalties, you're going to have to do whatever it takes to jurisdictionally avoid the mark of the beast. It's not going to be easy. It's going to be tough. I've studied for this for decades. All of this is going to all of the teachings, all of the instruction that I'm going to be bringing to you in this and other videos is going to clarify it for you. You're going to be able to see, and then what will happen then? You'll have a decision to make. You'll have a decision to make. I've made my decision. I'm not going to take the mark of the beast. I don't want to be part of a church that is not under God's sovereignty and jurisdiction, because I showed you the jurisdictional and the legal and the actual problems with that. I'm bringing those out. Now, I don't expect, like I said, I don't expect you to act right away. I want you to watch the video. That time go by. Watch it again. Watch it a third time if you have to. Think about it carefully. Search the scriptures. Read the scriptures with a jurisdictional and legal lens, and you'll see. You'll see what things are. I know this is tough. I wish I could make it less direct, less rough on you, less abrupt, but I can't. I am obligated before the Lord. It's my reasonable duty before the Lord to share with you the truth of His Word. And that's what I'm doing right now. So, my cameraman says there are no questions to be asked. We're going to close out this video. I will see you in the next video on this same subject matter. This has been another Investment in Truth Review instructional video by Pastor Mike Benjamins Jr. of the Remnant Church in Southern Oregon, USA. It has been an honor and a privilege to be able to instruct you in so important a subject matter. Thank you for your attention, interest, consideration, and support. This is Pastor Mike saying, take care, and as applicable, God bless.